put out a bench warrant for your arrest.
You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm propria persona.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense.
I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace, and
sir.
I'll travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White.
All right, everyone. Today we're watching a sharp, no-nonsense judge face off with a very disruptive sovereign citizen, and things get intense quickly. The defendant refuses to stay quiet, no matter how many times the judge tries to keep the hearing on track. Despite multiple warnings, this individual continues to interrupt and argue, ultimately making a serious mistake that completely backfires. The judge remains calm and firm throughout, and when he finally responds, it's a powerful moment and, honestly, very satisfying to watch. As you're watching, let me know in the comments how you think the judge handled the situation. Personally, I think he showed great...
All right, on the telephone ending in 1336, tell us your name, please.
I come in sui juris.
Only one of you actually has that phone number, and the other people are just wrong about what their phone number is. Who's calling ending in 1336?
Sui juris and personal persona. I'm Stephen hyphen Tyrell White, beneficiary and sovereign. I'm here under fraud, menace, and duress. Fiduciary Daniel Williams Norbeck.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try to come to court.
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and or $500 fines and costs. Do you understand your charge?
Objection, Your Honor. I do not. I do not understand my charges or
okay. I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor. Your Honor. You practice in front of bench. You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm propria persona.
Okay, Mr. White. I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I don't listen. I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me. Okay,
but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, can I ask to dismiss the charge?
With two completely different questions back to back, he really needs to focus. And no, he absolutely cannot. Get this case dismissed at this stage. It's clear he doesn't fully understand how the court process works. Just to clarify, this isn't a trial, it's a preliminary hearing. Yet here he is, tossing around legal terms as if he's some kind of expert. Unfortunately, his confusion is obvious. From the way he speaks, it's clear he doesn't really grasp what's happening. It's like watching someone get lost during the introduction phase of a process and already start making major mistakes. What do you think? Should the judge cut things short or allow this to continue for another
point? The prosecutor, there's no sworn testimony. There's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, with Your Honor, I'm the beneficiary and I'm a sovereign. I'm here under fraud, menace,
Okay, sir, those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
So
my
I've
constitutional
indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all of this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read. I'm saying I do not. At this point, Your Honor, I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's what I'm saying. It's a subject matter jurisdiction. Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. I'm not sure you do.
The judge is handling the situation with impressive skill and composure, while the defendant struggles to follow even basic courtroom procedures. The judge stays one step ahead, firm, focused, and completely in control. You can tell he's experienced and isn't falling for any of the typical arguments that often come from sovereign citizens. In my opinion, many judges tend to either get visibly frustrated or let these types of cases drag on too long. But this judge strikes a great balance. He shuts down the nonsense quickly, but he does it with professionalism and calm authority. It's clear he knows exactly what he's doing. If you've seen Judge Oakley in action, you know he can be pretty vocal and direct with defendants. That approach has its place. But I personally prefer this judge's steady and composed demeanor. It shows real confidence and control. That said, I know some of you might feel...
The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection. I'll travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond, sir.
It has to be. Before we can proceed,
White,
before you can proceed, there has to be
Mr.
address, Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, We will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand those two options, A and B?
That's a violation of my constitutional rights, Your Honor.
Well, no, it isn't, sir. So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date?
You, Ed, never ceases to amaze me how sovereign. Citizens just refuse to listen. In this case, the judge clearly explained that the next court date would be sent by mail, but the defendant still acted confused. I guess he was too focused on rehearsing his script to actually pay attention to what was being said. This isn't a school presentation. Memorizing a few lines doesn't help when the judge is clearly outlining what's going on. Honestly, if he had just listened and cooperated, he probably could have resolved the case with a simple guilty plea, a fine, or maybe a few classes. Instead, he chose to be combative and now he's at risk of spending time in jail. It's frustrating because the court often provides the simplest way to handle these situations, and yet some people still find a way to make things worse. I truly don't understand the mindset. What's the end goal here? To prove a point that no judge is going to accept. The legal process is straightforward. Show up, listen, and respond. Respectfully, but instead, we see people arguing over unfounded theories, thinking they've uncovered some hidden legal loophole that just doesn't exist. That said, I'll admit they do make for fascinating content. Let me know in the comments how you feel about how the judge handled things. Personally, I thought he was measured and fair. I know some people think these judges come down too hard, but I don't agree, Anne. I'd love to hear your take. Thanks so much for watching. If you enjoyed the video, don't forget to like and subscribe. I really appreciate your support. Take care, and I'll see you